Highlighting of submissions?
Highlighting just a few sentences.
No, I'm not close to that authority. I'm only here to take particulars of the sureties, period. Those are the instructions, and that's where the legal mandate ends.
On that note, Your Worship, then will move to identify the legal sureties as directed by the judge.
Receive particulars of sureties is a disparity in the handling of bail applications. And there is no law that permits a registrar to have that power and mandate. Your Honor, I'm well aware that Section 43(2) of the Judicature Act, Section 43(2) of the Judicature Act provides that where there is no procedure laid out for the High Court in any written law, where there is no procedure laid down for the High Court by any written law or practice, the court may, in its own discretion, adopt a procedure justifiable by the circumstances of the case. That's what that provision says. This provision refers to the High Court sitting and a matter of procedure arises and the law is not clear to that judicial officer. Then that High Court judge will then, in his seat, exercise discretion as the circumstances of the case warrant.
I appreciate the express desire that I have, express desire by the registrar. So I'm not acting under instruction, but it's my desire.
Can also attest. Just a second.
I just want to clarity. The provision is reading. I want to be sure that we are in sync.
Oba okugamba nti leeta documents zirungi kubanga yiisi yasalawo kibanga bwe banaatuma owa prison
My humble request and appeal.
Yes, sir. Ekiddiriramu ekyo kyonna kwe kumanya nti tujja kukomawo ng'ennaku z'omwezi 5 luliba lwakumeka lwakuna naye omukulu ateekemu okusaba kwe kwabadde agamba n'ebirala ebisigadde tulindirire naye ebisinga okumanya kamu bino abadde batagoberera twabiwaayo mu buwandiike neera mu buli olaba ateekawo akakodyo nja kuba mmenyese nja kuba kakati ne process eno olaba tebaagala egende mu maaso kakati yeetuuma training n'agamba nja kuba mmenyese ate nja sijja kubaawo so nga ate olwasooka ffe twakkiriza ng'agamba agenda ggulu ku train tukozese buntu bulamu naye kwegamba ensi buli bweggwamu amazima ebyo byennyini bye mulaba kwegamba mwenna mu kirabi omuntu omu n'agamba agenda kwanguwa aveeyo njagala aveeyo ate n'amala n'agamba alindira eddala oba alinda kibawo ekyokuyiga kingi nti okuuma kw'ebigambo kutono nnyo nti mu sekendi emu omuntu yeefuula nga neyeefuulira ddala kwega buli kyayogera naye katubirekere kooti munda kati neeyo lesoni mugiyize wano ti agamba nalwadde enkya nakoze kino nga bwe bakwongerayo dda nga wayise omwaka dda nga bwe nakibagamba nti baba banoonya bakutulwayinge nga wayiseewo n'emyaka nga 9 ndowooza mukiyize buli siteepu gye mulimu wano ebeere lesoni eri abantu mmwe abali ebweru kigaana ate aba alagiddwa anti kiri kiba kiragiro kya kooti ebyo ababadde mu makooti ga wansi abambi n'abakyala ababadde kuno okuyimirira nga bw'olabye wejaaka kola kulaga nagaana gwange si gugo gwa ofiisi wagugyewo okuba ogugwo ndowooza okiraba kibanga bwe nagaa nti nze baguwadde nze kati nga bw'owulira nti ayogera agamba nagwange meaning atadde feeling muki musango mu kifo kati feeling eyo muganda afaye agambye lunaku lwange lwakweraga lwakwemulisa kale yeebale kwemulisa salirawo kooti okujja kuba kulamula kwa kooti naye tulazeeyo abeeyimirize ebirala twabiwaayo mu buwandiike ludda lulamuzi wa kitongole nze simanyi omulamuzi twamuwadda pleadings zaffe okuwoza kwaffe mu buwandiike era batwongedde tukole okwa peegi emu mu buwandiike singa wabaawo agamba nti oba oyo gwe baleese si yoyo oba ebimukwatako si byebyo kakati ffe katulinde after all tebawakanyiza nti si yoyo oba babiwakanye mu buwandiike
just as in bail application. Yet in all instances, the trial judges have often authorized registrars to conduct identification. In my view, the identification of sureties does not amount to a hearing of an application, because the sureties have already been identified in the pleadings and in the submissions. There is no illegality that is being condoned, which is feared by the prosecution that respond in this application. For registrars to conduct identifications, the role of this court here ends at certifying court that indeed what was recorded by court under the pleadings, that's the notice of motion and the affidavits, and the submissions is what the applicant is presenting. With all the above said, this court proceeds to have identification of sureties in this application conducted. I so order.
Most obliged, Your Honor. In a division like this, where there are other judicial officers, what is too hard with another judicial officer today hearing this matter, one authorized by law, today? That would be justice, that would be equity, that would be good conscience. What is too hard with that? Let Mwizera have his day before a judge and have his application determined.
Your Worship, counsel is delving into matters.
No, my lord, you know, counsel, you are not going to divert me.
Your Worship,
I am responding to section.
It shouldn't be restricted to what we stated earlier.
I'm responding to section 14(2)(c), and that is what was raised.
Your Worship, we need some order in this.
My brother, please do not distract me. For your record, I cannot be distracted. For your record. Most obliged. And I request my brother, respect and decorum.
When he raises up, take a seat.
And I think senior to him, we should really respect him.
And submissions, far from it. And there is no practice I brought to the attention of court that has been adopted before. You know that there is a very big difference between a registrar appearing in a matter such as this and adjourning, then appearing in a matter as this and receiving particulars of sureties. When a registrar sits, and there is no doubt, once an illegality is brought to the attention of court, court must not close it. My senior brother, the Honorable Nsereko, said that I had said, and I wrote him verbatim, that I had said that this court has in the past adopted the practice.
Has not directed you to determine the substantiality of the witness of the sureties. The trial judge's directives are very clear. Receive the sureties. And Your Honor, that is a noble duty that everybody should be in position to appreciate. First and foremost, the documents are already on record in regard to the sureties.
43. That subject to Article 133 of the Constitution, the officers of courts of judicature shall perform such duties as may be assigned to them under the rules of court and shall be subject to general direction and supervision. And also 43(1) states that there shall be such officers of courts of judicature as may be necessary in performance of any such special duties in connection with the business of courts of judicature. And such officers may include the chief registrar, registrars, deputy, etc. Your Worship, when we were
My Lord, Mr. Amarit Timothy, Mr. Pima Jamil, Karua Eno, Inju Iron, and Awel Susan. Awel Susan.